Can you really beat a debt collector lawsuit without a lawyer? You're going to find out. I'm here with John Skiba. John, how you doing?
I'm great, Philip. How are you doing today?
Good to be here. Good to be here.
Yeah.
I'm Philip Tyrone. I host the Bankruptcy Explained channel, and I'm here talking to the expert about can you really beat one of these lawsuits without a lawyer? And let's unpack it.
Yeah, it's one of these things where debt collection lawsuits are filed in gigantic volume. I mean, gigantic volume. I'm here in Arizona, in Maricopa County, and the last statistics I saw, it's usually about 10 to 20,000 lawsuits a month are filed in Maricopa County
Um,
for collection of debt. So a lot of people are dealing with this. Um, the statistics overall nationwide, though, less than 1% of people who are sued by a debt collector actually hire an attorney. So most
wow.
people that are litigating these cases, they're doing it on their own.
Mhm.
Um, and, we can kind of dive into what I see as kind of the, I guess, pros and cons of doing that. And, can you really do this on your own? Is a good question because a lot of people do it. Then, a number of people are successful at doing it, but I can share some of the things that I see those who
Yeah.
are successful.
Do you have any stats on how many win? So if let's just say 20,000 lawsuits a month, the 1% file on their own, right? Like,
Yeah.
we have any stats, or do they not publish those?
I don't have statistics on that. I mean, we've talked about on the channel before, 95% go to a default judgment.
Mhm,
So we're really only dealing with about 5% of that.
mhm.
As far as those who win, a lot of it, I guess I would argue too, we need to define what win means.
Okay, yeah.
If someone's suing you for 10 grand and you settle it for 3,500 bucks, that's a win to me. You just save $6,500,
Yeah. Mhm.
But as far as how many actually win outright, where it's a dismissed or a judgment in their favor against the creditor, I think that number is very, very low.
Yeah.
Um, and the reasons why, and we can kind of jump into those. The reasons why I see it, the challenge that what we call pro se or pro per representative, people representing themselves in court, is one, the court process, no matter how many access to justice programs we see through the court system, and even kind of some of the um, different approaches courts take to make it more user friendly. The courts are fully aware of this problem. We see it with landlord tenant issues. We see it in debt collection issues where there's not attorneys there. There still are these rules involved. There's the rules of civil procedure. There's the rules of evidence, and they will often make them a little more user friendly. But at the end of the day, the consumer is going against an attorney or a law firm because the creditors always have an attorney.
Yeah.
In most states, it's actually required that they have an attorney, but they're dealing with attorneys that this is all they do.
Is all they do. It's almost like you're always against home field advantage. Like you are always on their, like they're walking in with a huge advantage, obviously, because they do this all the time. And
Yeah.
it's like, I mean, if you miss one thing, I mean, I would imagine it gets thrown out or something happens, right? I mean,
Well, yeah. When the first thing people do, like I said, they don't respond, so the courts just rubber stamp it. And
yeah.
I can tell you this: this is my own opinion, is that the judges who see most of these are in my state in Arizona. They're in the justice courts. They deal with lawsuits under 10 grand. They see so many of these, and almost all of them end up in a default. There can be, again, my opinion, maybe a little institutional bias
Mhm.
against consumers and against pro se litigants because you're just stamping these default judgments all day long.
Yeah.
Or you see people who do respond and come in. Maybe they're not prepared. They don't know the rules. Because most states do have this rule that's a part of the case law of the state that says that a self-represented person is held to the same standard as a lawyer,
Yeah.
which is not fair because, someone that's litigating against me, I've been all day long for 23 years. This is what I've been doing. Whereas someone this is the first time they've been in the court system, it can be difficult.
Well, I mean, let's stick on that for a second because that's a really insightful point. Because I would think that they may be a little more lenient on a self-represented client. Like, hey, I got this big law firm or a big debt collector sue me for $10,000. Okay, I'm going to try it on my own. And what you're saying is, per the state law, they're held to the same standard. Like a lawyer who does this all day long for the last 20 years, going up Grandma Jones, whatever, is
Yeah.
held to the same standard.
Yeah. And, when you see it in practice, it makes more sense on,
Yeah.
just kind of in theory, it sounds horrible and
I
completely
mean,
unfair.
really, I
Yeah.
would think I would have thought differently. I would have been like,
Yeah.
"Oh, they're gonna give me a break, they're gonna I can make mistakes." But no.
Yeah. Like, so let's say you're in a trial type setting and, there's these disclosure rules that require the parties, they have to exchange the documents months in advance of trial, basically so that everyone has to show their cards. There's no unfair advantage. If a consumer shows up and says, haha, Perry Mason moment, I've got the thing that helps me win, and the other side says, I've never seen that before, the rules don't allow it. It does put the other side at an unfair advantage, and so a court could, if they were lenient, they might say, "Well, they didn't know," but then you can see very quickly it devolves into this thing where it's just not a fair, the rules are designed to create fair, level playing fields,
Mhm.
but if you're not aware of the rules, that's where the problem is, but the rules are what they are, and so, the courts are in a situation where they're like, and I have seen judges, they'll let things slide a little bit, but if the rules are not being adhered to, the courts really say, "Look, our hands are tied." Or
Further, because there's a process. I mean,
yeah,
if it happens this, I mean, it becomes very gray and difficult to
yeah,
move things through the system. Okay.
yeah,
Yeah.
yeah. So it can be very difficult, for consumers to do it, but the number one thing I see for those who are successful in getting cases thrown out, is they are there. They are participating. They're filing the answers. They're showing up to the pretrial conferences, the Zoom calls, the all the stuff along the way. They're not late. They're submitting documents, even if the documents aren't perfect. They're submitting what's been
Yeah.
requested of them. And it's a little embarrassing even for me how many cases I have won because I have done that.
Yeah.
Um, because if you show up to trial and the attorney's stuck in traffic somewhere, a lot of times the court's going to throw it out. I remember one time I had a case where that happened. I showed up, the other attorney wasn't there for the debt collector, and the judge said, "Well, let's give them a little bit of time, see if they show up." And I had to go, "Respectfully, Judge, if my client hadn't shown up, judgment would have been entered 10 minutes ago." And the judge said, "You're right." And he dismissed the case.
So how long is that waiting like, if someone obviously 2 minutes, it's one thing, but what was that time period?
It was less than 10 minutes.
Oh, was? Oh, it really is.
Oh, yeah. The courts, if you look at their calendars, particularly the busy ones that deal with debt collection, landlord tenant, they're booked. I mean, some of their calendars are quadruple booked. And so,
Wow.
particularly for attorneys, I can say this is where you might get a little bit of leeway, but being on time is a huge thing. And for most courts, they're like, look, if you're not here, you must not want to prosecute your case, or you may not want to defend your case. So we're done. We're throwing this.
You called the client, you're like, "Dismissed,
Yeah.
100%." You're like, "What the?" That's
Yeah.
great.
Secret trick. I showed up. So,
Good.
yeah. So that's kind of the main thing I see that them do. I can tell you, this is going from, maybe this video was like how to prevail, but also some of the things, the downside to it. It takes over your life because you're not familiar with it. I see people, you go to work all day and you come home and you're researching all night, okay, how do I do this? How do I do that?
Learning curve is overwhelming,
Yeah.
overwhelming, right.
I can tell you, in the new AI ChatGPTs of the world,
Oh, yeah, yeah.
that's a powerful tool. You gotta be careful. There's a lot of attorneys that have gotten themselves in trouble by submitting things that weren't accurate to the court, but it is a tool that can help you get up to speed and at least kinda start down a path, that I've recommended to people that can't afford attorneys. Like, "Look, this may be an option to at least kinda help you,
Yeah.
as you're trying get through this process." Um,
I wanna go back to what you said in the very beginning. I think it's really, really important. What is winning? Because what I was when I read that in the beginning, in my mind, I'm thinking winning a lawsuit, I'm talking 0. I'm not like, "Oh, the Perry Mason moment," right?
yeah,
Of like, "Ha ha,
yeah,
you don't get nothing." But the reality is that's probably very rare, right? Like, extremely rare, except with a default judgment that, like, it goes either side
yeah,
absolutes, right?
yeah.
And it really is a function of like, "Hey, what are you settling for? What are your other options with your other debt, et cetera, et cetera?" I mean, I think that's a good point. You need to know that going in. Like, what define a win?
The other thing I see, a lot of, people believe that they're gonna go to trial and the judge is gonna try to negotiate a settlement, or you're gonna be able to explain to the judge, "Hey, I lost a job, I can't afford this, so what about this?" I always say the best way to view the court system and the judge is the umpire. They're calling balls and strikes. They're gonna say you're liable or you're not. You either win the whole thing and you owe zero, or you're going to owe the entire thing plus attorney's fees, plus interest, plus court costs. Um, so there's a lot of risk in going to trial.
Wow.
And so when we talk about winning,
Yeah.
that's why I say if you get sued for $10,000 and you can settle it for 3 or $4,000, I always say if I would have told you that a year ago, hey, this 10 grand, we can get rid of it to you for 4 grand, you'd take it and be done with it. And so sometimes I think people will get a little too caught up in the process
Mhm.
when we really need to keep the big picture of your goal is to get this thing out of your life for the least amount possible. If you go to trial and you lose, you're rolling the dice and you could lose big, and then they have a judgment and they can garnish. And then a lot of people, frankly, that's what pushes them into the bankruptcy route. Whereas if they come in and there's a settlement that makes sense for your situation, it may not be a bad idea to entertain that.
Well, I gotta tell you, I don't even think I was realizing that. So you're saying because the settlement has to happen before the trial. If you take it to trial and the judges call them balls and strikes, it's either liable or not liable. I mean, that's like you're taking it too far almost, right?
Yeah, and also because if judgment gets entered against you,
Mhm.
then you're in a situation. I always look at settlement when we're trying to settle it. I always am trying to present facts, hardships, things like that that would make it so that, maybe showing that how difficult it's going to be for the creditor to collect.
Mhm.
And so that gives us a little bit of leverage in trying to get the deal done. If it goes to judgment and the judgment's been entered against you, things have shifted dramatically in favor of the creditor.
Yeah.
Now they have a lot of tools that they didn't have before, and the settlement's going to go high. So you may be able to settle early on in the lawsuit, for 35%. Once a judgment gets entered, it's probably 60, 70, 80% that you're going to end up paying. So um,
Yeah.
we really have to, take all that into consideration. And I always say this, it doesn't, even if you have a really perfect case, settlement allows you to at least retain some control over the final outcome. If you go to trial, at the end of the day, it's up to the judge. These are rarely go to juries, so it's usually up to a judge. And depending on what that judge's inclination is, even if your case is great, I've lost a ton of cases I should have won, and one cases I should have lost.
Yeah.
So you never know. You never know literally what's going to happen at trial.
And in the end, John, just because of the way our bankruptcy laws are protected, for those watching that have lost the case or where you're getting bombarded with lawsuits, there's always options, right? You're never out of the game. There's always a way to restart. And even though there's laws on how often you can file bankruptcy, if we've had clients that have filed bankruptcy and then got in a horrible car accident and just they're trying to dig themselves out, and you can go into a different type of bankruptcy, like a 13 temporarily to, like, stabilize the payments. But
Yeah,
my point is there's always a light at the end of the tunnel. See, people get so siloed in the negative. "Oh my god, I can't handle this anymore," right?
yeah,
And they start beating themselves up because who do you talk to about this stuff?
yeah.
I mean, you're alone, you're confused, you're isolated, and then you deem yourself powerless. And my point of this is why we started Bankruptcy Exchange, why you started Consumer Warrior, because there are options for people. So,
Yeah, and I always say the bankruptcy option, it's always in your back pocket. And particularly if you say, okay, you know what, I feel like my case is good, I'm going to go to court, you go to trial, and you lose, which a high percentage, particularly of self-represented consumers do. I mean, it's just the reality of it. We talked about it. The deck is kind of stacked against you in going into that. Even with great facts and the law's on your side, it's tough. So if you end up with a judgment, the bankruptcy option is there to deal with it. And the bankruptcy option, I mean, one of the most powerful parts of the bankruptcy process is that it is something called the automatic stay. As soon as you file that case, it stops collections, stops that lawsuit, stops them from garnishing your wages, stops them from leaning your home. And then you can deal with it and eliminate that and all the other unsecured credit cards, personal loans, all that kind of stuff. All that can go away. And so you have that that's kind of in your toolbox of how do I deal with this debt problem. Sometimes it's best to visit that even before the lawsuit starts, or sometimes the lawsuit's just the final straw that someone says, look, I got to do something here. We got to get it done. But even after a judgment's entered, you can still file a bankruptcy at that point and stop all the collections and get rid of the judgment altogether.
Awesome. If you want to talk to John Skiba in Arizona or an attorney like him in your state, it's the links on his channel right at the very top, and we're here to support you. John, the consumer warrior, thank you for your insight and your time.
Yeah, Philip, I appreciate it. Great talk today.
Talk to you soon.